We'll be starting shortly for those of you who are joining us. I think we should be about ready.
Okay.
Tiff, how many we got?
We are at 67.
Okay, let's give it another minute or two.
Yeah. We got a bunch of people probably trying to log in right now. Larry will start in another minute. If that's okay.
I'm not going anywhere.
Okay. All right, everybody. I think we're going to start at this point. There's a few people still logging in. I'd like to thank everybody for attending today. This is going to be, this is our first of many educational sessions that we're going to host. And today we have a great topic on New Jersey Tidelands. We have expected over 200 people that are supposed to be on the call and some group viewings as well. So we're excited. This presentation is presented by the companies of the Jordan Group and Larry Bell from CATIC Title. The companies of the Jordan Group include Quality Title and Abstract Agency, the Jordan Appraisal Group, Title Link and our friends at Better Homes and Gardens Murphy and Company, Domus Title Agency with our friends at Cochran Sawyer Smith, Bluestone Title with our friends Mike Burney and Don Malagna. And for those that don't know me, I'm Jim Jordan. I run all the companies. I'm a certified real estate appraiser and licensed title officer in 12 states. And I would like to first start off by thanking our clients. We appreciate your loyalty and working with you through the years. And I would truly love to thank my staff. I have a team of rock stars that without them, that none of anything that we do for our clients and the existence of our company being in business over 40 years would not be possible without a fantastic team that I have behind me. I'd like to introduce our presenter for the day, Larry Bell. I've known Larry Bell for we were just coming up with a number of over 30 years at this point. He is the guru of all things New Jersey title. And when people ask me complex questions, if I don't know or my staff doesn't know, most likely I went to Larry Bell, asked him to chime in and provide some insight to me. He's been a valuable resource, and he's going to be a tremendous resource to you right now on this topic. This is one of the most confusing topics, I think, that is presented to us, because nobody pays attention to it until you're dealing with a property from either from a realtor standpoint or a lending standpoint that has a New Jersey Tidelands claim. And at this point, I'm going to hand it over to Larry.
Thank you so much, Jim. Before we get into the material, just a couple of comments on my relationship with Jim. The thing that impressed me so much from the beginning, going back over 30 years, is how Jim always embraced emerging technology. And if you go back 35 years, there was no technology. So everything was emerging, and Jim was always cutting edge, which has kind of put him in a position where he's always been ready for everything that came along. It's one of the reasons I really enjoy working with him, with his team. I've known all of them for a very long time, and I'm honored to be asked to do this program. We are approved for one CLE credit. There will be 3 polling questions. Everyone is certainly free to answer the polling questions, but for any attorneys that are going to be receiving a credit certification, that's kind of important. If there's more than one attorney in one location and only one name is signed on, please send us an email to credits@catictitle.com. Tell us the names of the attorneys that were present for the 50 minutes of content, which we're about to begin, and we'll make sure that the attorneys get credit. At some point in the future, we will be adding broker credits. Jim will certainly keep you advised on that. Hopefully before the first quarter, by the first quarter of next year, real estate broker as well. We know that we have attorneys, we have real estate brokers, we have lender personnel, we have all of the real estate professionals that work with Jim and his various different companies. And today we're talking about water. Water in New Jersey is very confusing because it's a bit of a moving target when we talk about rights and defining property rights. I think that after this hour that we're going to spend together, you should have more sensitivity to some of the issues. Water, of course, started as commerce and transportation. Commerce comes from Latin. It means dealing together, trading together. It's about the common rights, and we're just going to start a little historical review with what happened in Rome in the year 528 during the reign of Justinian I. He appointed a commission to review all of the Roman laws and printed or finalized the Code of Justinian, the Codex Justinius, in the year 534, a few years ago. Corpus Juris Civilis, the body of civil law, talks about the rights of the public. Public places such as buildings, theaters, race courses, all belong to the municipality, the city. Sacred or religious places are holy, subject to divine law, belong to no one, but the air, running water, the sea, the shores of the sea were common to all mankind. So this was the first statement as to rights in terms of water rights and water usage and water right ownership and riparian issues. Roman law started with a definition of the seashore, which was as far inland as the greatest winter flood may run up, including the ground, lands, or sand beneath it. So we're talking about the ebb and flow of the tide. The law of nations at the time allows seafarers to approach the shore, moor their boats, erect a shelter, haul their catch, repair their nets. Anyone on the sea was free to approach the shore for safety, for purposes of attending to the business of being a seafarer. We do have water rights addressed in the Magna Carta in 1215. A statement, chapter 16, clause 23, states that no riverbank shall be placed in defense from henceforth except such as were so placed in the time of King Henry, our grandfather, by the same places, same bounds as they were in his time. And what the statement means is that riverbanks, seashores, could not be utilized for private purposes. They couldn't be utilized. You couldn't move them around. You couldn't change them to get a better flow, to deal with drainage. And then in 1239, the Statute of Common Law England, public has common law rights to the sea, seashores, as well as the right to use riverbanks to anchor, to tow, and to moor vessels. So, you know, we're going quite a ways back in time to address the very basic foundations of, you know, land ownership, so that when you're dealing with a client, with a purchaser, with a property owner, with a borrower that is involved in a transaction that has water rights of some kind, and their position is, you know, what do you mean I don't own it? What do you mean I need a license? What do you mean I need to do something different? You know, the basis of all of those positions comes from these old English laws, which flow from Justinian and the Romans. Here in America, let's move forward to the middle of the 1700s, late 1700s. An ordinance was adopted by the US government for the territory northwest of the River Ohio. And in that ordinance, that law, it contained a statement that said the navigable waters leading into the Mississippi, St. Lawrence, and the carrying places between the same shall be common highways and forever free, as well as to the inhabitants of the said territory, citizens of the United States, any of those other states that may be admitted into the Confederacy without any tax, impost, or duty therefore. So it's a point in time during or right before the Civil War. We're still talking about admitting new states into the Confederacy, and we're establishing the orderly nature of waterways and water rights being available to all for transportation and commerce, common highways, free forever. And then fast forward to the 1800s, we start seeing some New Jersey case law for our attorney friends. They love cases and cites. 1821, the New Jersey Supreme Court defined or enunciated the public trust doctrine in the decision in Arnold v. Mundy. This was a case where the owner of land abutting the Raritan River, he seeded oyster beds and then, you know, excluded others from the oyster beds, and was looking to fish these beds, stating that these oysters were his. He did the farming, he did the planting, he did the seeding, and the court said, sorry, the air, running water, the sea, the fish, wild beasts are common property to be held, protected, and regulated for the common use and benefit of all. We then had a United States Supreme Court case. New Jersey is very lucky. This was a New Jersey case that ultimately went up to the US Supreme Court, which affirmed the common law right to fish in navigable waters, tidal waters, as they were owned by the state of New Jersey for common use. And the Martin v. Waddell decision actually cited to the Magna Carta as its legal basis. So the connections between what has happened before and where we are today cannot be ignored. Getting more into the specific decisions that affect the way we practice today, O'Neill versus State Highway Department was the seminal case that states that New Jersey or the sovereign owns fee simple to all tidally flowed lands up to the high water mark. We have a statute, NJSA 1810-5. All lands belonging to this state now or formerly lying under water are appropriated for the support of public schools. Monies are all to be used for the purpose of school funding. Interesting that that's the reason they came up with and the funding source, because anybody who made any noise was the counter argument was, well, you must be anti-education because all we're doing is looking to fund that. They did state in that case adverse possession doesn't run against the state for anyone that argued that open, notorious, continuous hostile possession should remove state rights. And the decision did address the Tidelands maps. And the Supreme Court said, you know, you really should come up with filings that establish the exact holdings. Where are the riparian claims that we need to be worried about if we're going to be representing parties to real estate transactions that abut water, that have water rights? We do have the 1980 case of the city of Newark versus the Natural Resource Council, which addressed the way the maps are to be established, addressed the establishment of the maps. There was a statute adopted which directed the Tidelands Resource Council to file the maps. Those maps were actually filed in the year 1982. There was a case, Dickinson versus the Fund for Support of Free Public Schools. There was a trial court ruling in July of '82 that required Tidelands maps to be filed by the state by November 2nd of '82. That was appealed. The appellate division site is 187 NJ Super 224, and ultimately went to the U.S. Supreme Court, 95 New Jersey 65. And the bottom line is that this map of New Jersey is it has a depiction of all of the tideland areas, all of the areas in the state that have areas that were now or formerly flowed by the tide. There are tideland claims areas in every county except Morris, Sussex, Warren, and Hunterdon. As you can see, all of these red boxes, which are basically key maps, you know, it's the entire Atlantic coast, all the way down, and then it is back into the bay, and then up the Delaware River is a tidally flowed area. So any area now or formerly flowed, as set forth on this map, are tidelands areas, and we need to be very careful. We need to make sure that we have grants for any claimed areas. If we're representing buyers, if we are counsel to the sellers, we need to make sure the sellers understand their responsibilities. And seeing that we're about 15 minutes in, we're going to take our very first polling question. Tiff, if you don't mind opening the polls.
I like that we have a couple of Jordan Group rocks.
Yeah, for them, the right answer is always the right answer. Okay.
Larry, if I can just chime in on with the map that you're bringing up after we can pull that screen down.
There we go.
This is one of the questions that I get when there's we run a tideland search and there's a claimed area, and the response from either might be the realtor or the lender or the attorney is, this is not sitting against the water, so what are you talking about? And as you can see, that it's not properties just immediately along the coast, it stretches inland, because there's times where there's title claims on a property that is very far away from the coast.
Yeah, I mean, I was a Bergen County boy from Hackensack, and Hackensack. Anybody who practices there knows, you know, before they built the parking garage, don't park behind the courthouse buildings if it's going to rain, because the Hackensack River, if at high tide, would flood. They built the Sanzari complex behind the courthouse complex, and I believe that a Tideland search really should have been done on that, and it wasn't. And there was a Tidelands claim that, if recollection serves, was paid by, I'm not going to say, but it's a very large city in Illinois, a company that had hoped that somebody would have looked for Tidelands claims, because they are areas that you need to be cognizant of. And we're going to talk about the appropriate exceptions that need to be taken. The problem with Tidelands claims, and the reason the maps needed to be filed, is that we're not dealing with something that's concrete. Water moves around, the tidelands move around, the mean high water mark moves around, the nature and extent of the land moves around. And we're talking about accretion, erosion, and avulsion. Well, more accretion and erosion than avulsion. Tidelands, we know, any lands that are now or were formerly flowed by the mean high tide of a natural water body, oceans, bays, tidal sections of rivers, creeks, marshlands. It's the boundary line between private ownership, or the boundary line between private ownership and public ownership is the mean high water line, and that fluctuates over time. What are we talking about? Accretion and erosion. Accretion, the gradual accumulation of sand, sediment, or other deposits extending the shoreline so slowly that the changes can only be seen over time. You know, as the ebb and flow of the tide deposits sand or takes sand away. Erosion, the opposite of accretion, the gradual and imperceptible reduction of dry land, which results in a decrease in the size of the owned land and an increase in the owned riparian land. So if you've got a riparian property and you've got a grant, and that grant was obtained in the 60s, and the map was filed in 82. For starters, the Tideland claim line on the grant in the 60s may not mirror the line in 82. And if there was erosion, it may be that there's now more dry land, or less dry land rather. If there's accretion, do you have more property? Or does erosion mean that the grant now needs to be expanded? You know, these are questions that we would look at when we're insuring a Tidelands property. Avulsion. Go ahead, Jim.
If I can just jump into there. So there are times where there's a Tidelands claimed area and it's completely dry. So that's another question that we get. How can it be a Tidelands claim area when, you know, it's dry and there's a building on it? So based on what you just explained, that explains it, that it formally flowed, and it might have been a very long time ago, but the state
Correct.
of New Jersey says I own it.
Correct. We're going to get to some maps that that will be an excellent illustration to that discussion. Avulsion is kind of important when we're talking about accretion and erosion, that we mention avulsion. Remember Hurricane Sandy? Remember what happened to Manahawking? Remember what happened to Seaside Heights? You know, huge areas of municipalities were gone. Beaches were completely gone. Rapid, sudden loss or addition of land. A rapid avulsion does not change property boundaries. No change in legal rights or shifting of any boundaries. We return to what the boundaries were before the avulsion. There is a New Jersey case, Long Branch v. Liu, stated that we long recognize that a sudden shoreline change has no effect on boundary. This was a case where, after there was an avulsion and a tremendous amount of sand washed away, there was pumping of beach sand to rebuild the beaches, and Lou claimed ownership as if it was an accretion where you would get more ownership. But they said, no, no, this was an avulsion and you don't get anything additional. So terms that we discuss when we talk about Tidelands claims, the grant itself is the deed from the state of New Jersey. If there is a tideland claim, it means that New Jersey owns a piece of your land. The claimed area is owned by the state. If you're a 90% tenant in common with your Uncle Max, who owns 10%, it's the same scenario as a 10% Tidelands claim. You can only own 90%, you can only sell 90%. The buyer wants 100%. So we would get Uncle Max to sign a quitclaim or join as a tenant in common. Here we need the state's interest extinguished, or we're going to take exception for it. A statement of no interest, we can ask the state, hey, do you believe you have an interest in the Tidelands? And you can get a statement of no interest where applicants prove beyond a doubt that they have no tideland claim to a particular parcel. Other things that you're going to see, if you're a broker, if you're a lender, certainly attorneys, title professionals are going to see in the records the possibility of a license or a lease. Licenses are short-term rental agreements for use. Use, it's like an easement, as opposed to a fee simple ownership. Fixed structures, bulkheads, extensions that exceed or will exceed the mean high water line, marina slips, yachts, boat structures, dredging within state tidal waters, utilities, utility-related structures, bridge construction, and bridge maintenance over state-owned tidelands. You're going to see a license in the public records. That license may have fees due and owing, and it may expire after time and need to be reapplied for. So if you have a buyer that's going into a Jersey shore property, an oceanfront property where there's a license that benefits the seller, that needs to be addressed to make sure that the buyer is getting all of the rights and that they've taken the appropriate action to enjoy the same benefits. Leases are longer term. Again, it's for the use of currently flowed tidelands. Generally, longer term projects, financing projects, as opposed to smaller construction projects. Leases can be obtained, or leases may be required for proposed construction as well as past construction. So a lot of times we'll see a seller who's looking to sell as is, went through 3 or 4 offers, got an offer, they're moving forward. And as the title work is being investigated, it turns out that something may have been done on this property for which there was no application, there was no permit, there was no grant, there was no right to do it, which means that the current owner may be responsible to take remediative measures, to do filings for existing construction, even though the current property owner had nothing to do with it. So a quick flip, somebody who owned it for a year and decided they'd rather live in the mountains, so that could cause issues that real estate professionals need to be aware of. So let's talk a little bit about Tidelands maps and what they say and what they show. This particular map is an overlay. It shows the Tideland claim area, which is yellow. It shows improvements, and it shows municipal block and lots. On this particular slide, this is Ocean City, by the way, you see all of these protrusions out here in the water. They're docks, they're wharfs, they are used for the access of the waterway. We also see water back here. And going to Jim's question raised, if this is all water, it says clubhouse, I think, over here. And this is all water. Why is it that the only tideland area are these yellow stream-looking bodies? Why isn't everything tidelands? And the answer is that in this part of Ocean City, this waterway back here is man-made. This bay, these entrances are man-made. If they're man-made, they were never flowed before 1982, which is the deadline for the state to establish tidelands areas. So the only area that we need to address for tideland purposes are the areas that were now or formerly flowed, which are the yellow areas on this particular slide. Let's look at lot 16. It looks like maybe 50% of the land is covered, whereas lot 10 over here has nothing, or has limited. 9 has almost nothing. An additional slide that's coming with the Tideland search, again on this particular piece of property, which shows the waterway to the rear and the water to the front. This identifies grants that have been issued. Every one of these circles, numbers in a circle, is a Tidelands grant. A grant issued on lot 20, a grant issued here, grants issued for this area, grant issued for this area. So if someone is buying lot 10, doesn't seem to have one, lot 18 appears to have a grant that would cover. 26 doesn't have much, but appears to have a grant that would cover. So we're going to find that, and we're going to locate that, and we're going to address that as we're looking to insure. Here's one that's actually on the ocean. This is the Atlantic Ocean. It's not a man-made area. So everything up to where the tide, the mean high water line, ebbed and flowed is a tideland area. This one, of course, the whole Atlantic Ocean area in here, everything that's yellow is tidelands. And this did not have much, waterways, streams, where some of those pencil streams that we saw on the last set of slides exist. Here, again, the tax map has identified some traditional grants or some grant areas. Grants, books, pages are all set forth. So we check to see and make sure that, it's the same way as doing a title search. Mom and dad owned, they sold, and then those owners sold, and the chain of title has to include everybody. It has to connect. It has to include all of the pieces. Here we're doing exactly the same analysis, but it's the piece that New Jersey owned that is in fact joined and becomes a piece of the land. The state of New Jersey interest is extinguished. And here again, this is the tax map itself, identifies the grants that we see. Some of the rules and exceptions, as far as title professionals, when Jim or his folks are dealing with property, they're going to run a search on anything that's close to any areas that we know have tideland claims. And if we do see that our area is claimed, we confirm whether or not there are any riparian grants that have been issued. It used to be that the searcher would go to the county and would look at the maps and would do all of the work themselves. Now we have a number of services. We have Western Technologies, we have Charles Jones. They all provide tideland searches and grant searches and overlays. Those maps that we looked at came from one of those services. If the grant search shows there's a grant, we get a copy, we review, we determine that the grant covers the riparian claim area. Keep in mind that if the grant is dated before November of '82, that the claim area might have been expanded. It might be different. So somebody who says, what are you talking about on the sale of a $6 million oceanfront piece of property? When my grandpa bought it in 1946 for $60,000, we got a grant from the state of New Jersey. Well, For starters, the good news is the $60,000 basis that Grandpa had certainly appreciated quite a bit to the $6 million purchase price. So they can likely afford the few dollars it's going to cost them to get a confirmatory grant or an additional grant. And when we say surveying work may be necessary in order to determine the additional area, how many additional square feet of Tidelands claim area may exist, how are we going to determine, what is the subject of what we're purchasing if we're getting a supplemental grant or a confirmatory grant. So we may need survey work. If we, a lot of times, and Jim could talk to this, people don't want to see costs get driven up. And nor do we. We're the first one to say we don't need stuff that costs money that doesn't add any benefit to the process. It may be that if there isn't surveying work done, that the buyer isn't going to be as well protected, and that they may be in a tough position if and when they become the seller at some point in the future. Once the grant is reviewed for coverage, we confirm that the grantee was the upland owner at the time the grant was issued. Very technical. You cannot become the owner of Tidelands if you do not own the adjacent uplands. So, and this is important, if somebody makes a Tidelands application in their own name and then they sell, and then the grant is issued in the name of the seller and not the buyer, that grant is no good. Because the law says that you must be the upland owner in order for the grant to be effective. Why don't we open poll question number 2? Tiff. Somebody has to think that a Tidelands grant is a water sports scholarship. I mean, come on, that's creative. Question, answer writing. Not one. And the nobody knows, of course, is a homage to Ned Borghese. Ned Borghese? Nate Borghese? Whatever. Current comedian.
There, you got one, Larry.
Thank you. Thank you. And we'll know who that is, too, when we see the report. We'll have to send you a special thank you. So I see we've got about 80% voted, so we'll leave it open or move on. So we do have Tidelands rules and exceptions that we take as title insurers. These are things that buyers and sellers, attorneys are familiar with, brokers, should anticipate that these are going to be, what the transaction is subject to. It's not as problematic as oil tanks that may be in the ground, and it is what it is. We report what we find. If the grant covers the entire claimed area, we show the grant. As an exception in B as follows: terms, conditions, limitations is contained in the grant. Also, I don't have a slide on it, but I'll mention it because we will offer it. Any CATIC agents would offer it. But if you're working with someone else, you should always ask for the Tidelands grant to be included in the legal description. It should be together with and subject to terms, conditions, and limitations is contained in a riparian grant. So if you're not getting the insured together with, that's a good thing to ask for if you're a buyer's attorney. It's pretty standard. And affirmative coverage, lender always wants affirmative coverage. We'll affirmatively ensure that the upland owner, that the grant was, the upland owner was the grantee, something that's requested, and it does take off the requirement that, or the issue that presents. We'll sometimes see shoreline grants that'll only cover the shore where the mean high water line meets the shore, but they can't be relied upon to cover interior streams. And we'll see that that earlier, the first slide that I showed that had the Tidelands map, those look like streams, inland streams. And if we were a riparian area and the shoreline was covered, it doesn't mean the stream was covered. We need to look at the definition and description of the Tidelands grant. And of course, that November 82 date is somewhat important. Grants after 82, way more reliable than grants before 82, but almost all of them were issued. I mean, so many grants were issued in the 30s, 40s, 50s, 60s as development was occurring along waterways. Best practice, as we said, have the grant and claim area plotted on the survey. There you know exactly what you're getting or not getting. If they don't match the claim line, they may not cover. An existing grant may not cover areas because of erosion by way of review. If we have waterfront properties, there are other rights besides just the ownership right of the state of New Jersey in and to land now or formerly flowed by the mean high tide. Waterfront properties, we insure up to the present or former high water mark, but not beyond. So any portion of the premises below the present or former high water mark of whatever the body of water may be. It may be a stream, it may be a lake, a tidal lake, it may be the ocean or a tidal stream. So waterfront properties, that's going to be a standard exception. Also, the rights of the federal government, as all of these laws have been formulated and proposed and adopted, well, the federal government says, wait a minute, we have a paramount right to regulate and control navigation and to change and establish bulkhead and pierhead lines. Navigation, going back to case law and law school days and programs that address, you know, what is this navigational servitude? What's the definition of navigation? And there was case law that basically said if you can float a cork down a waterway, it is a navigable waterway, which means, you know, the stream where your kids are catching frogs could certainly float a cork. So that may be subject to the rights of the federal government to regulate navigation. Also to take without compensation any lands now or formerly flowed by tidal water for the purpose of commerce and navigation. You know, the taking without compensation is the rub on that one. Federal government, you know, no government can take without just compensation, be unconstitutional if it wasn't for tidal lands, ungranted tidal lands that are owned by the state of New Jersey. So that's the federal government exercising its dominion over the state. Beach access, also something very important, becoming a lot more, or has become a lot more with some of the case law and decisions over the last 10 or 15 or 20 years in New Jersey. Subject to the rights of the public in and to the beach, dry sand area abutting the Atlantic Ocean, its bays, tributaries for the purpose of access to the water and recreation. You cannot exclude people from beach access. There are areas that have closed beaches, but generally public rights in and to beach areas is something that is established again by common law. And last but not least, we're getting closer to the end of specific exceptions that you're going to see, which are standard, would be private rights. Rights public and private, together with flooding and drainage, if any, in and to all streams, rivers, lakes, watercourses, crossing, bordering, or affecting the land. And this is the exception that addresses rights by and between adjoining property owners that may both be on the same stream or river or watercourse or lake, where one property owner is seeking to take some action that may benefit their property, but may have a detrimental impact on their neighbor's property. So you can't, that wouldn't be a title claim, because we're going to take exception for the possibility of those private rights. If somebody wanted to know what the full-blown, most extensive, verbose, attorneys drafting by the word, description of a New Jersey exception for tidelands, now or formerly flowed, it would be this bold paragraph. Title right or claims of the state of New Jersey to any part of the insured premises which is or may be alleged by the state of New Jersey to be or is determined to be salt marsh, tidelands, meadowland of land now or formerly flowed by the mean high tide of the ocean or any bays, rivers, streams, creeks, or their tributaries. As Jim again said, it can go back 100 years. When they established the maps in '82, they used whatever was available. They used descriptions. They used chain and link descriptions that tied to waterways. They came up with every possible way to establish that they have areas that they know may have been flowed. They may no longer be flowed because of redirection, because of working towards better drainage or flood prevention, or the creation of canals. We did a program last month. CATIC does a monthly webinar. You'll all be invited, where we talked about what happens to the canals in New Jersey that were established in the 1800s. The Morris Canal, a number of others. In New York, we have the Erie Canal. If they were tidal areas, then they may still need to be granted, even if those canals are no longer being used for canal purposes, if they're now being used for private purposes.
And this is, Larry, if I can step in on that, what Larry just had up on the screen is as the exception. That's when the confusion typically starts in a transaction, that there's a tidelands claim, there's an exception because there's no grant in place, and now everybody's saying, now what? And then the arguments about it's totally dry, it's not near the water, it's only a little sliver of the property, and it says, 1 to 5%, but it still needs to be addressed.
And when we say it needs to be addressed, how do we address it? Do we have to hold up the closing until we get a grant out of the Tidelands Resource Council? No, we can always figure out an escrow. We're going to hold some of the seller's money. It's the seller that's going to be paying for whatever interest is established to be in the state of New Jersey, because the seller doesn't own 100% of what they're selling. It is only based on the value of the land, not the improvements. So if you have a multi-million-dollar home on the Atlantic Ocean, it's only the Atlantic Ocean land, not the multi-million-dollar home, that needs to be factored into how much the price of the land is going to cost. And what we do is we use the tax and assessment search to determine a percentage. You're going to look at the tax and assessment search. It's going to say, for example, land 500,000, improvements 3 million, and it's a $6 million sale. That would kind of make sense. So we know that 500,000 that's a sixth of 300,000. So we know that the value attributable to the land is 1/6 of the value of the entire parcel. And then we look at either the purchase price, which is fair market value, or possibly fair market value if we're finding through riparian issues and claim issues, sellers cleaning it up on their own, there's a refi and we need to take care of it. We may just use fair market value, but we multiply the value of the land itself, 30%, or we multiply the 30% times the price, we get the value of the land, and then we take the amount of the claim. If you're claimed 100%, it's 100%. Jim mentioned, a 1 to 2% shoreline claim. Those are easy. 2% of that number may be 10 or 15 or $20,000. 50%, of course, it might be a lot more. Once we have the number, the value of the fair market value, from a rule of thumb, from a Tidelands perspective for underwriters, we multiply that number by 2 to 2.5 times. And the reason for that is because the timing of obtaining the grant is such that it's going to occur in the future. Cost is going to be determined probably 2 to 3 years into the future, maybe not as far, but certainly it's going to be a future date. Property appreciation is going to be a factor in determining the grant costs. I had an application where we thought that the fair market value of the land was $250,000 to $400,000, and then there was a bit of a delay in the application being filed, and by the time it got to the Tidelands Resource Council, the property was worth $1 million. So quick appreciation, and that's something that we needed to deal with. Written escrow agreement always needs to be used. Anyone that's holding an escrow without a written agreement, shame on you. 9 real serious important reasons why to use a written agreement. Whose money is it? What are the terms under which it's being released? Generally, the costs are going to be doled out of the escrow during the process of the application. And we need to know who's responsible. We're going to get documents signed at closing, cooperation agreements, and assignment from the seller to the buyer. If it's the seller's responsibility, but the buyer is the one that's going to benefit, it's going to be issued in their particular name.
And if I can chime in on that, the process takes time. So I've had conversations with people saying, I'm just going to call the Tidelands Bureau and I'm going to get this straightened up, and I'm going to, where can we apply? I need to close next week. It takes time and it costs money. So obviously you're going to talk a little more about that, but it's not something that can be cleaned up in a week, 2 weeks, a month, just to get the loan closed.
Another point, and we know people in the Tidelands Resource Council, and the question is, what's going on? We've got grants that have been approved by the Tidelands Resource Council. We know what it's going to cost, but the grant is not being issued. It's being held up for some reason. And I'm not just talking a week or 2 or 3. There are grants that we're aware of that were finalized over a year ago, and they haven't been signed by the Attorney General and submitted to the governor for signature. I don't know why. There's a pile of approved grants on the Attorney General's desk. So it's not the Tidelands Resource Council that's contributing to the extensive delays, although their process also takes time. So yeah, we can generally escrow for almost anything that is ascertainable, anything, estates, transfer taxes, inheritance taxes, judgment amounts, mortgage liens. We'll always find a way to get you closed with an escrow agreement so as not to delay. That's kind of what we do. Some additional water issues that come up, which are a little bit skewed off of the main question of, do we own the land or does the state have an interest? Condominium buildings that have a Tidelands claim that only affects common elements. We know the Galaxy in North Bergen has Tidelands areas that only reach the land and do not get to the improvements themselves. And we've been taking exception, just stating that the common elements, the Tidelands claims affect common elements only. So it's up to the condo association, if anyone were to come along. It's not a lien, it's not a specific issue on an individual's title. Also, we have wetland, flood zone, and environmental regulations that apply. We're not addressing those today. Those would be a topic for another conversation. But wetlands, flood zones, and environmental regulation, very important. CAFRA permits, Army Corps of Engineers. Anytime anything is done on the water, you're going to need permits, even if it's not a riparian area. All those docks we referenced on that initial Tidelands map, they're going to need permits. They may need approvals to effectuate those, even though it may not be a tidelands area. We also have lake association issues that have become very much in vogue. The Highland Lakes v. Franzian case, 2006. This is one where people that had nothing to do with Highland Lakes, they're nowhere near Highland Lakes, they don't enjoy Highland Lakes, they don't use Highland Lakes, they don't fish in Highland Lakes, they're blocks and blocks away from Highland Lake. The Lake Association went back to the very earliest deeds that addressed communities and started billing everybody for possible lake dues. Big issue, big problem. People were prevented from using the lake if they didn't pay their lake dues. They were liens against property. We're taking exception. It becomes a real issue. It's something that if you are on a lake, you need to consider it. We did have a subsequent case law, Crispino versus Township of Sparta, that talks about properties needing to be benefited. This one really applied more to dam repairs, but getting very close to the end of the program, we got to do poll question number 3. So let's open that up, please, Tiffany. And thank you to everyone that's paying attention. So those pretty much are all of the issues. I'm sure somebody's going to come up with a water issue that we didn't mention today. But that's a very good overview of how rights have been established, the rights of the public, why they exist that way, and hopefully we've clarified any issues, or at least highlighted the areas that you may encounter in the future. Jim is a wealth of knowledge, information, and experience. We are always available to assist in any way that we can. CATIC Title has been out and about for 7-8 years. When we opened our doors, we had no agents, no revenue. We weren't selling anything. We're now the largest smaller, underwriter, knocking on the doors of all the big guys, but we've surpassed all the regional underwriters because we address things from a perspective of how can we advance the best interests of the industry? How can we advance the best interests of buyers and sellers? How can we be the title company that's most interested in positive transactional outcomes? And that seems to have been a very good game plan for us as we grow. And it's, of course, a game plan that's embraced by Jim Jordan and the Jordan Group. With that, I see it's almost 1 o'clock. We are available for questions at any time via email. Tiff, any quick questions come in on the chat?
Only one. The question was a list of counties that do not have tidelands issues.
Yes.
Sussex,
okay.
Sussex, there's only 4. Sussex, Hunterdon, Warren, Somerset?
I believe that is correct.
Yes, that was a little quiz for myself.
Yeah. Let's just go back to that map that we looked at earlier that locates, where exactly the tidelands areas are. And, this is something that we share with our agents, as an overlay. And you can superimpose, the address of your property. If it's right around here, even though we're in a county that has tidelands, we know there's no tidelands over here. The only 4 that have no tidelands are 1, 2, 3, 4. A little bit here, an itsy bitsy teeny piece in Passaic. So it's pretty easy to locate the areas that do have tidelands. And with that, I see it's just about 1 o'clock. We were required to do 50 minutes of content, even with the introductions and the I love Jim and Jim loves me. I think we got 50 minutes in. And I want to thank everybody for participating. And Jim, I'm going to turn the program back over to you for a few closing words.
Thank you, Larry. I appreciate you sharing your knowledge with everybody and demystifying a frustration that many in the real estate community have. Please keep us in mind. Between our companies, we offer title insurance in 13 states along the East Coast and appraisal management services in 5 states. If I can help you, any questions, you have access to me, you have access to Larry. If we can help you in any way with this topic or others, please don't hesitate to reach out to us. And we appreciate everybody taking the time to get together with us.
Thank you very much. Enjoy the rest of your day.
Bye.